plans, I end up creating 7 to 9 documents on average, okay? Some of them they'll need, some of them they won't, but at least they're covered. And that's the main thing we're trying to do today, is to get yourself covered. Now, okay. As I say, there's 2 different things we're talking about: late life planning and property disposition.
This call is being recorded.
Now, types of late life planning documents you may need. Some of them, a lot of these you'll recognize, okay? There's a medical power of attorney. Now, you could, of course, try to leave, just if you're happily married and your spouse is in good shape, they can help make medical decisions. But, what if something happens to them? I have seen many circumstances where kids have different ideas on how mom should be taken care of, okay? They take them to different doctors. They start, and it, suddenly sibling rivalry, you're caught in the middle, okay? So someone needs to be in charge in case you can't make decisions yourself, okay? There's a HIPAA form, which is just about getting access to records, because normally, no one can access your records. Do you want, all your kids to be able to access the records, or just some of them? You can do this form, and that can be done. Of course, there's a regular power of attorney, okay? Those are fine for taking care of day-to-day stuff as you get older, so that, your daughter or whoever can do the day-to-day tasks. However, that's not really an estate plan, because once you pass away, they expire as well, okay? So that's when they cease being effective. There's a directive to physicians, which is sometimes called a living will, which I never really liked that title, but what a directive to physician is if you're terminally ill, you're not going to get better, okay? You're out of your head. You're going to be plugged into a machine for the rest of your life. Do you want to be plugged into that machine? Okay? You do not want to leave that decisions to others, okay? The doctors are generally ethically bound to keep you alive. So you could be plugged in for 10, 15 years, just totally out of your head. Or it may fall upon your kids, and you don't want them arguing about it. And quite frankly, even if they're all get along, you don't want them to bear that burden, okay? No one wants to say, please unplug mom, okay? It's just not a good thing, okay? So that's a very important document. There's a do not resuscitate directive. That's for really, you're very sick and in a lot of pain, and you just don't want to go on forever. So if you stop breathing, please don't wake me back up, okay? That's really what that is. A remains directive. Remains directives are basically who's in charge of the funeral, okay? I have had kids grabbing mom and taking her to different funeral houses and not telling the other kids, okay? Fights over the body, or particularly when, let's suppose mom was married twice, had 2 sets of kids. Well, do they end up, does she get buried next to husband number 1 or husband number 2? All those type of things. You have to have that. That's why you have to have somebody in charge. We're going to save questions for the end, since we have a lot of people online, okay? Hold on. This thing just jumped ahead a few pages. Okay, another thing is you can nominate a guardian for yourself. Okay, what if you need a guardianship sometime? Who do you want that to be? Okay, I've seen too many times where the person who wants to be the guardian is someone who just wants to live in the house and lock mom up in the back room. That does happen. You don't want that. Who's really going to take care of you? Okay. There's a supported decision-making agreement, which is just so other people can talk to the doctor with you as you get older and help you keep track of stuff. If you have young children yourself, you can nominate someone to be their guardian. Okay, very useful document. This thing is driving me nuts. Okay. This is jumping all over the place for some reason. Okay. Yes. Well, it's not only that, it's like these aren't even, pages aren't even, they're in weird order, quite frankly.
It might be, I don't know if it's a different version, but
Okay, well, we'll have to deal with it. Okay. Yeah, go back to page 6. I'll just go with there. Okay. Now we're going to talk a bit about property disposition. Okay. A lot of people think, well, I just have to write a will and that's good enough. Okay. And a will is very important. Everyone should have a will. Okay. The problem is probating a will. Okay. Probating a will is difficult. First of all, to probate a will or any estate in Texas, you have to have an attorney. That's going to be $200 to $400 an hour. Okay. So you really don't want to go through probate if you can avoid it. Okay. Because someone's going to have to be paying that bill. The other thing is the probate courts are very backed up. There are 2.7 million people living in Dallas County. You want to guess how many probate courts there are? 3. That's not enough. Okay. So probating it, and what's going to be happening while that case is sitting there? Well, the attorney's fees will keep being racked up. Okay. So you really want to, we want to avoid probate, but you still should have a will just in case. Now, a will must be probated within 4 years of death. You have to, don't try to just do a will on your own, quite frankly. Okay. Be very wary of wills off the internet because each state's laws are different. Okay. And if it doesn't satisfy Texas law, then it's either going to be no good or you're going to have to, do a bunch of extra work. Okay. There's certain magic language. Okay. I've seen a lot of like wills which are typed and then signed and then a couple witnesses and a notary stamp. And it's not going to get you there. Okay. Format is incredibly important on wills. Okay. You either at least want to make sure it is a Texas specific will or go to attorney. Even a handwritten will is better than what I see off the internet. Okay. Quite frankly, I'm not a great proponent of them, but at least they can be valid. As long as they're entirely handwritten, signed, dated, it stated it's a will, it's still a valid document. Okay. Now, of course, like I said before, you should always do a will because we're going to be talking about other ways to pass along your estate, but one of those might fail. So a will is like a security net just to catch any asset that you haven't figured out to transfer it another way. You might forget to address something, or maybe right before you die, you inherit something or win the lottery or something like that. You still always want a will. Okay. Another thing that comes up way too often is people can't find, someone passes away and either one person rampages through the house, okay, and if they don't like the will, they get rid of it, or no one can find things, okay? So there are things you can do. One, you can file your will with the county. It will deposit, which is basically run by the probate clerk. That's an easy way. It keeps it safe. You should have, you can keep the original of your documents with whoever you're putting in charge and just keep a copy for yourself. So don't let your, whoever you want to be your executor have to hunt them down. They should already have them before you pass away. You can get a safe deposit box as long as someone else has a way to access it. At a minimum, a security box, those little fireproof boxes that you can get from Home Depot for like 50, 60 bucks. At least that's something. But you have to keep these things secure. Okay. You want to make it easy on whoever's going to be managing your estate. They shouldn't have to be trying to find stuff. One thing that's very useful is creating a list of useful information. Because the courts are going to be asking questions about, okay, what's the family history? Who are all these people? Or just to find the assets. So you want to have a list with your marital history. You want to say where all the life insurance policies are, just a list of it, list it out. Pension documents if you have it. Bank accounts, okay? Just don't put down Wells Fargo, put down the account number somewhere, okay? Let them know where stuff is, okay? If you have a safe deposit box, where you have land, maybe you have like a small interest in the old family farm off near Marshall or something like that, or some mineral rights interest or something like that. You need to make a note of it so that people are aware of it, okay? Because if they don't know about it, it doesn't get addressed and eventually it gets lost, okay? And of course, information regarding your debts, who all your kids are. You assume they would know it, but heck, not always. Names and passwords to online accounts. Okay, we do more and more online. Google will not give you passwords, okay? Not without going a court order, okay? So, it's fun to try to guess those. I've had to do that, and sometimes you get them and sometimes you don't, all right? And of course, funeral arrangements, okay? If you know what you want when you pass away, somebody needs to know, okay? More than just the funeral home, okay? Because again, maybe your kids have different ideas than you do, okay? So you want that down, and a copy of your latest tax return, because there's always useful information in those. Just 1 second. Slow on. There we go. Okay. Now we're going to get into ways to avoid probate. The biggest one is generally your house. Okay. And fortunately, Texas has two different ways to transfer property without going through probate. Okay. One is called a transfer on death deed, and the other one's a ladybird deed. And they have a lot of similarities and some differences. But basically, when you do these, either one of them, you still own your house. Okay. You can still sell your house. You can still do whatever you want with your house. However, when you pass away, it will automatically transfer over to whoever you listed down as the heir. So, very useful thing. In other words, no going to court, basically filing one document into deed records. Much simpler to do. Don't even need an attorney for that. Okay. So, they don't count as a gift for gift tax purposes. You can still claim it as your homestead and still get all your exemptions. You can change them anytime you want. They don't affect your qualification for Medicaid benefits. as long as you still reside in the house, and we'll talk about that in a few minutes. They also allow for what we call a step up in basis. Step up in basis is I've seen some people do this, which is, well, I'm going to just do a quick clean deed of my house to my kids now, and then that way we don't have to worry about it. Well, that's fine, and that works to a certain extent. The problem is it causes you a tax problem, which is basically whenever they try to sell the house in the future, they're going to have to pay a lot of capital gains taxes. So you really don't want to do it that way. Much rather do a transfer on death deed or a ladybird deed. Okay, now there are some differences, so it's always good to ask someone which is the better way to go. If there's a mortgage, generally transfer on death deeds are better because they don't trigger the due on sale clause in a deed of trust. Some lenders think that ladybird deeds do. So if you've got a mortgage, probably want a transfer on death deed. Todd's, they'll have a look back provision, okay? In other words, creditors, if you pass away and pass over the house to whoever, there's a 2-year period where creditors can try to go back after the house. So if you don't have a mortgage, I much prefer a ladybird deed, okay? Because they don't have that look back provision. For there, the creditor's pretty much out of luck, okay? Just go to the next one. Now, a transfer on death deed have to be filed in deed records before death or they're invalid. But quite frankly, if you do either of these, a transfer on death deed or a ladybird deed, just go ahead and file it in the deed records. Like I said, you haven't lost your house. You haven't lost the right to control it. Just get it filed. Get it done with. Okay. Now, if you're trying to do some fancy plan and want to say, well, who gets the house after that heir or a contingent beneficiary, well, then you may have to change things up a bit. Those you might use a transfer on death deed on, but that's a very case-specific situation. Okay, now, one thing that I've noticed in the past several years is there's a cottage industry among private attorneys of creating trust. They say, oh, just put everything into a trust, okay? It's a way to charge you $1,500 to $2,000 fairly simply. But are they necessary? Quite often, no. Okay. Now, trust can be useful. If you're a very wealthy person, there's some tax reasons why you might want one. But unless you're a multimillionaire, those aren't going to kick in. And if you're not a multimillionaire, the reason you would want a trust is if you have to control something for a little bit longer after you die. Okay. Suppose you want the house you have a disabled brother and you want your disabled brother to be able to live in the house for the rest of his life type thing. And then you want it to go over to your kids only after that. Well, that's something that a trust would be perfect for. Okay. Because when you would essentially deed the property over to the trust, you pass away, your disabled brother gets to live in the house. When he passes away, house goes to kids. And guess what? You haven't been to court at all throughout all that thing. If you do the deeds and the trust correctly, you're not even in court. Okay. It's just what you want to have done. Okay. There's two different types of trust. There's ones you can revoke and ones you can't revoke. The only reason you would want to do one that you can't revoke is maybe you're concerned about being sued over something. If you're a businessman or something like that, and so there's always a danger of litigation, someone going after your assets. If a trust owns that property outright, the creditor can't go after that, okay, if it's in an irrevocable trust, but that's a case-specific situation. Okay, now, trust and Medicaid. This one's kind of interesting. There's really two reasons you would use a trust in regards to Medicaid. Because in Medicaid, there are asset limitations and there are income limitations, okay? However, if you put a property, let's suppose you have too much property and you're not going to qualify for Medicaid. If you timely put your property into a trust called a special needs trust, guess what? It's no longer at your property. It's now owned by the trust. You have the right to live there under the trust and so forth, but Medicaid doesn't count, okay? And you think, well, but Medicaid doesn't count it if I live in it anyway, so what's the big deal? Well, suppose you have to go into a nursing home, okay? If you have to go into a nursing home, guess what? They're going to want to sell that house in order to pay for the nursing home. That's the biggest way, okay? Once you move out of that house, it's fair game. However, if it's already in this trust, they can't touch it, okay? It's already gone. So that's one thing. Another thing is if your income is too high, you can bring down your income by doing what's called a qualified income trust. I really don't do many of those or any of those simply because working at legal aid, no one qualifies if their income is that high. But it's another way to bring down your income to qualify for Medicaid is a trust. Okay, now there are other ways, simple ways to avoid probate. I had a lady call me recently and she said, well, my mother left $20,000 in her bank account and we can't get to it. Well, no, you can't. Okay. She would have to go through probate and all that other business. Okay. Again, starting to pay the $200, $300 an hour or whatever. Okay. Well, all you have to do, if you do it before you pass away, is go to the bank and either put someone else on the bank account if you really trust them, or at a minimum, put a payable on death provision. In other words, who gets the money if you pass away, okay? The bank they're perfectly happy to do that. They love to do that because it simplifies their lives, okay? I put my sister on mine, for example, just in case something happens to me, she can just go get the money. She doesn't have to go to court, do anything like that. Insurance. A lot of people get insurance and they think, well, I'm not sure who I want to make the beneficiary. You have to put a beneficiary down, okay? Always put a beneficiary down. If a beneficiary dies, you better go change it, okay? Because if you don't, the only way those payments get made is if they go to court, do a full probate at the estate, figure out who the heirs are, and then they go. So if you have a beneficiary provision, please always fill that out. Automobiles are simple, and yet no one does this. There's two forms put out by the Department of Motor Vehicles, which you can find online, the VTR 121 and the VTR 122. And they're kind of like that transfer on death deed. Again, you can still sell the car, do whatever else you want with the car. But in case you die, all they have to do is provide the death certificate and they get the car. They get a new title, okay? So you just have to fill out the form, file it with the Department of Motor Vehicles, and you're done. The 121 form is if you're giving it to an heir. The 122 form is really for when two spouses are on the name of a car, okay? And it's like, well, you don't have to go to court just to get the deceased spouse name off. You want it to automatically transfer to the living spouse, okay? Heirlooms. Okay. I think we've all had this situation where someone passes away and some cousin or sister or something goes through the house and starts snagging stuff, okay? I had my own sister start to do that, and I said, "Oh no." Okay. I mean, she showed up with a box. I'm thinking, no, 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 no. There's 6 of us here. This is not how that works. Okay. Heirlooms are a little tricky. Obviously, you can put them down in your will in terms of who gets what, which is always a good thing to do just to show your intent. And of course, the other thing to do is simply to give those away at a certain point. Okay. If you have, something that you want your niece or something to have, go ahead and give it to her now. Okay. At a certain age, particularly when you're downsizing and you don't want to keep all the stuff in the house anyway, um, go ahead and give it away. Um, One, you made sure that they got it. Okay. And 2, you get to actually enjoy their happiness in receiving it. So it's a good thing just to go ahead and give certain family items away. All right. Okay. Now, I'm going to talk about a couple related topics. Affidavits of heirship. I'm not a big fan of them. Okay. Sometimes they're the only thing you can do. But affidavits of heirship are simply this form, an affidavit filled out, signed by a couple people who knew the family, who says who the heirs are. There are problems with them. Okay, first, they don't give clear title. Okay, you can only give clear title if you did one of those, like the transfer on death deed, the ladybird deed, or a judge says who the heirs are. Okay. Affidavit of heirship doesn't give clear title. I would not buy a property from someone if they only claimed it through an affidavit of heirship, because people lie. It's one of those things. I had this one where I had 5 siblings come in, okay? And they wanted to do this affidavit of heirship. Okay, fine, da 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 da. I do a little hunting. Guess what I discovered? A 6th kid. Okay. Had to call him on it. Okay. And they fessed up at that point. He came by and so forth. Turned out he wasn't the black sheep of the family. He was the good one. Okay. The rest were all up to no good. They just didn't like him because he got to be raised by the grandparents. So they just ignored him. It's like, no. So that's why they don't give clear titles. And most title companies won't accept them. If they do, they can be liable. I had one recently where a house was sold. A title company accepted an affidavit of heirship. But the affidavit didn't list one of the kids. The kid came to me, said, "Hey, I didn't get anything." I wrote a letter fortunately, they had gone through a title company. I wrote a letter to a title company, proved, say, "Hey, you got this extra person." They just sent a check. Okay. And now they're suing the other kids because they had to pay extra money. Yeah. So not a big fan of them, but sometimes they're the only thing you can do. If there's no estate plan, sometimes it's all you can do. Now, this topic is very ancillary. It's reverse mortgages. And I simply put this in because I have seen too many people my age or older who go out and get reverse mortgages. Really try to avoid them at all costs, quite frankly. I mean, if you simply have a cash flow problem, and you can pay it off quickly, that's fine. But it does not make sense for a 65-year-old person to get a reverse mortgage with, 20-year payoff. There's just so many problems with them. First of all, you lose that right to get a tax deferment when you're 65. You lose it. You got to keep paying taxes on your property. Okay. You have to keep up insurance on your property. Now, hopefully you keep it up anyway, but what if money gets tight as you get older? Well, you've blown the money already you got from this reverse mortgage. You can't defer your taxes. You're having to pay all this extra insurance. You're getting kind of stuck. When you pass away, the heirs must repay the reverse mortgage, okay, if it's still outstanding, which often it is. And they have to pay it off often within 6 months, okay? And if it's a good chunk of change, maybe they don't have the money, okay? And then you got a whole nother problem. Okay. Lastly, in Texas, of course, we recognize common law marriages, but a lot of people don't understand what a common law marriage is. They just think, well, we've been together for 25 years. Everybody knows we're a couple, so we're common law married. Doesn't quite work that way, okay? There's 3 requirements. One of them is simply that they live together as spouses. That's just one of them. They have to tell everybody else that they're married, okay? Including like filing joint tax returns, things like that. And you have to have proof that they agreed to be married. And this is usually the big problem, okay? They come in, the surviving spouse comes in, says we were common law married, but I've got no way to prove that the deceased person ever agreed that they were married, okay? And if you can't prove it, you're not common law married. Really what you should do is if you don't want to go through a formal marriage ceremony, at least go to the county and register the common law marriage. Okay, that's easy enough. Okay, takes 15, 20 minutes and then you're done. Okay. Okay. So that's really the bulk of the presentation today. So now how are we going to do questions? Okay, we'll do questions from the room first. Okay. Ma'am, I think you had a question a while back. If you
saying earlier about children,
you're going to speak.
like what you were saying earlier about children, if you're married for the second time and you have 2 sets of children, you have already made arrangements for your previous will. You paid for it. You got a copy and you gave it to the one that's going to be over anything that happens to you or your spouse. That child can prove to the other children, these were the specs of our parents. This is what they wanted. Those children can't change it, right?
Okay, so if I understand correctly, what you're saying is a person was married twice, and at some point they did a will putting someone from a child, I think from the first marriage in control, and from the second marriage in control, saying what they want to have happen. And what you're concerned about is, can the children from the first marriage say, we object to this and da 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 da? Okay. No, they can't. Okay. As long as that will is valid, written correctly and proven up, done correctly, your last will that's valid is the will that's enforced. Okay.
The first marriage didn't have a will or anything. And the second children had disagreed that, no, I want to bury my mother and my father. That's not your parents' wishes.
Well,
written in the will. Cremated.
Well, that goes back to one of the prior documents, because you're asking now about the will saying that you wanted to be cremated. As I mentioned before, there is this other document called a remainders directive, which puts someone in charge of the funeral and all that. And that's generally where I put that, yeah, I want to be cremated. Okay. And it's a separate document that you essentially just give to the funeral home, and the funeral home is much happier when they get the document. Okay.
That's who we bought ranch with.
Okay. Well, exactly. Okay. Okay. Another, yes, sir.
two questions. Will versus trust, and you did state that you can have an irrevocable trust, but wills can be contested. Now, I have a will, but it still can be contested. So,
Well, technically, okay, so basically, just for what you're asking about is contestability of wills versus trust. Okay.
correct.
Wills are easier to contest. Okay. Now they both can be contested, but a trust is a lot more difficult to contest. Okay. But yeah, a will is much simpler. Plus, again, you're having to go in to probate the will. You're having to go in front of a judge anyway. So it gives the opportunity for everybody to say, hey, there's a problem here. We disagree with this. A trust is a lot more difficult simply because a trust is more or less like a contract. I mean, and if it's dated, signed, filled out correctly, there's not a whole lot they can do with that one. So trusts are are more difficult to attack. Certainly agree with that.
Okay, the second question. Unfortunately, my aunt passed, no will. I'm having to go through probate. Number one, I don't understand why we just only have 3 probate courts in Dallas County.
The legislature.
I'm going on my 5th year trying to get through this probate. And you're absolutely correct. The attorney fees are exponentially high. But going through this affidavit of heirship, the probate court assigns an ad litem attorney, and it's their responsibility to find errors that are perhaps unknown. Am I correct?
Yeah, when you do any type of probate, yes, they're going to appoint what's called an attorney ad litem. And attorney ad litem, their main job is to see if there are any errors out there, okay, that got missed, and to double check everything, okay. Yeah, it adds on another layer of complexity. That's why when I was talking about things you want to do ahead of time, one was simply creating a list of who all your kids were, living or deceased, grandkids, all that business, so that so that everybody already has that information. Makes it a lot easier. Now they'd still have to double check it, but that's what it's easy enough. It makes it much easier for the ad litem too, if they have something from you saying, hey, these are the people I know of. Okay.
Your parents had a will, had a trust for a will. And one of the children that your last living parent agreed to do a family agreement. Does that family agreement overrules the will?
What can happen sometimes is, oh yes, sorry. So what you're asking about are these things called family agreements, which sometimes occurs during a probate action. Okay. Sometimes when it's not entirely clear for some reason in terms of what's supposed to happen, maybe the will's a little vague, maybe something wasn't addressed. And so people are arguing about it. Sometimes the heirs can enter into it's really kind of a settlement agreement to settle the litigation so that they don't have to spend the tens of thousands of dollars is to fight it out in court. But if your will is really clear and doesn't have problems, that shouldn't be necessary. Now, mind you, of course, any heir can always waive their interest. I've had situations where, one of the children became incredibly rich and said, you know what, I don't need anything. Okay. I just want some personal effects or whatever. Okay. That they can do. Okay. But family settlement agreements are only when there's some legal dispute because something, generally it's only because there's some legal dispute because something's a little vague.
So you would need to take that to probate court.
Oh, yes, it would still, there would have to be probate court action, and that would have to be filed in the court case.
If he has a question online, go ahead and raise your hand.
You got court.
Requires a bill. Did you give an example of that?
Oh, yeah, I'll give you my favorite one because it always, what she asked about was what type of language that Texas specifically requires. She just wanted a specific example. And my favorite one, because it always causes a laugh when I'm getting the will signed, is it has to state that the testator is at least 18 years of age and that the witnesses are at least 14 years of age. So I have people in their 80s just laughing hysterical saying, yes, I just passed 18. Yeah, so something like that. So that's a common one. But if they don't specifically mention that, what has to happen then is you would have to go into court, bring the witnesses in court and say, yes, I was at least 14 when I witnessed this will. Okay. So that gets to be a problem because, of course, who knows where the witnesses are? Maybe you can find them, maybe you can't.
Have a lady birthday and you end up in the nursing home and they attach the.
Okay, that's a good question. If you have what she was asking us, if you have a ladybird deed, and you go into a nursing home, can they attach the property? They generally don't with a ladybird deed. Could they? I don't think so. The smarter thing to do though is to have that special needs trust that I mentioned. That I know they can't take, and I'm pretty sure they can't do it under a ladybird deed either though.
Let's say you have two parents, one child, and one of the parents passes away. The other parent's raising the child, no debts or anything. It is assumed that everything will go to that one child, or all of the paperwork, all of the paperwork that they're referring to the deed and all of those, they still necessary in a will. And lastly, what's the average cost of the will?
Oh, okay. There were a couple things there. One question was, what's the average cost of a will? It really depends who you go to and how complicated it is. I mean, $200-300, I guess, is probably fairly standard. And your other question was quite interesting, which is if two parents, have a child, they don't have any other children outside of marriage, just them. One parent passes away, so now you're just having one parent and one child. Is all this really necessary if there's only one child, only one heir? And the thing is, yes, because you have to prove it. Okay. You need something saying that this is the only child. Okay. You can't just go off of people's words off of that. So it's a question of proof. And if you have a transfer on death deed, payable on death on the bank account, all those other things, you don't have to prove that this is the only child. You don't have to go through that. You don't have to get the guardian ad litem that this gentleman mentioned appointed to look to see if there are any other people out there. Okay. So yeah, it's still necessary. True. And the estate, I forgot about that. Very good commissioner. And yeah, the estate ends up paying for the guardian ad litem as well.
There's a few questions online. The first one is, do you recommend a trust if you want to leave life insurance / pension to an underage grandchild?
Yeah, actually, that's a good idea, quite frankly. You know, when it comes down to leaving, you know, money to minors or so forth, for people who still might be minors, you don't know, you know, at the time you pass away, a trust is very useful for that. And by the way, you don't have to give it to them when they're 18 either. Okay. I generally advise against that. I mean, if, you know, if you're giving, you know, $15,000, do you want to give $15,000 to an 18-year-old? Probably no. Okay. You know, they'll just go blow it on something stupid, most likely. Okay. Let them, you know, get on their feet, learn how to work themselves, that type of thing. I mean, I have had people put it in that they get the money when they're 25, 30, 35. I had one person even say 40. They wanted to make sure they, you know, learned all those good life lessons of hard work first before they got this extra money. Okay. Oh, and another thing you can do with a trust, though, you can also specify how the money can be spent in the interim. Okay. In other words, maybe you want to make it available for college. Okay. That's a perfectly valid thing to do. Okay. So instead of blowing the money on a new car when they turn 18, if they go to college, this will help pay for the tuition. Okay. That gives you what I mentioned before. Part of the idea of a trust is it gives you control after you, for a while longer after you die. Okay. And that would be a great time to use one. Yes, ma'am. Well, that's one of the group. Okay. Um, that's one of the groups who could benefit basically for tax reasons. But for the rest of us, okay, it's really when you need control after you pass away for a little while longer. Okay. He gave the example of a minor child. That's a time that you would use a trust. Or again, to qualify for Medicaid benefits, that's the time to use a trust. There's various circumstances that come up. Okay. What I don't advise is that everybody get a trust, because that could simply complicate matters. Sometimes you need it, sometimes you don't, but it depends on the circumstances and what is it you're trying to do. Okay. When a person comes to me for an estate plan, the first thing I want to know from them is, what do they want to do? Okay. I don't ask them what they want. I ask them, what do you want to do? How do you want this to happen when you pass away? And then we figure out how to do it.
So to this question, also have Greta and Burton after.
Ms. Lawson?
Yes, I'm here. I was wondering, I am currently taking care of my stepdad and has been for the last 15 years, and his children are not involved in his life, his biological children. When he passed, what is it that I'm needing? He doesn't have property, he doesn't have anything that could be willed, but like for the funeral, he's 85. What documents do I need to be the overseer or handle his affairs, which I handle now anyway? I just didn't want the children to come in once decisions has to be made when he passed or whatever.
Well, okay. The question comes down to, well, there's a few things. One of the most immediate things you would want to get is what they call a directive, a remains directive, putting you in charge of essentially the funeral and all those type of arrangements. Okay. Now, then after that, it depends. You know, it sounds like all he has are personal effects. Okay. You know, some of those personal effects, if he wants to someone specific to get them, it's probably a good thing for him to go ahead and give at least the more important ones away at this point. So no one can argue about it, because you can't argue about, that, someone giving something to somebody. That's easy enough. You know, that's the big one. You certainly want what we call the directive to physicians. In other words, if he's ever terminally ill and so forth and can't make decisions, does he want to stay plugged into a machine? You want a medical power of attorney, because what if he's, again, nursing home, something like that. Who's going to make the medical decisions? Right now, it wouldn't be you. It would be those kids out there, and they may not have his interest or know what he really wants. Certainly want that for now. Okay. If he has a bank account, you want a payable on death provision on his bank account so that those funds can transfer automatically. Those are the things that jump to mind.
Thank you.
Question. While Ms. Burton comes off mute, there's a question here. So how do transferring stocks for investments work after death, or if we don't want the individual to touch it until a certain age?
I'm sorry, could you repeat that?
Investments work after death, or if we don't want that individual to touch it until a certain age.
Okay. There's a couple ways about. One question is one question is going to be how the stocks are owned. For example, if you have a money manager, say someone at like Wells Fargo or Edward Jones or one of those things, they're held by an account. And what you do, you can actually put a payable on death provision onto that stock account. That's one way to address who gets them. Now, if they're underage, well, that's when you might want to consider, again, a simple trust circumstance. You would make the payable on death provision over to the trust to a minor child, figure out who you want to be the trustee. That's the big question. And then at that point, you can direct, okay, at 25, they can get it outright and do what they want, or whatever you want to put in there. Okay. So that's the way I would look at those.
Screen.
Okay, I have two questions. I was just wondering, how do we get your contact information to secure you to be our representative?
Oh, okay.
And that's the first question. And the second question is this. A person is interested in retiring their debt a lot faster than it's going. Would you advise them, what would you say if a person has a house and their interest rate is 2.75? Would you advise them not to refinance that house if they're in their 70s?
That's one I'm not qualified really to advise on.
Okay, then. All right.
Yeah.
Okay.
Now the math thing I'm not going to tackle. Okay. Yeah, that's a little bit beyond my scope.
But in your wisdom, though, if your interest rate is that low, wouldn't you just stay put and not?
Oh yeah,
move on it.
Common
Yeah.
sense makes me say,
Right.
if you got a 2.7%, why do you want?
That's what I'm saying. Okay, great.
Yeah.
All right. Thank you.
And you're
Yes. Okay, and to go back to the other question, I work for Legal Aid of Northwest Texas. I try to do all the estate plans myself if I can. We have hopefully showing online how to apply. For those people who are in the audience who I maybe didn't talk to, who want to try to apply directly, there's just a slip of paper that can be filled out and left at the front.
Thank you.
Yeah, and for those online, we can also send that questionnaire that they provide if anybody wants to sign up for their services. So you can send it online as well.
I'm interested. Please send it to Ophelia Green, okay, at AOL.com. Thank you.
I'll send it to everybody in the.
All right, appreciate that. Bye.
So question from Ms. Deborah, what happens after you put the house into a Lady Bird deed? What about the house insurance that is in the house and its parent name? Do you transfer the house insurance into that trust?
Okay. There's a little bit of confusion in the question. A Lady Bird deed doesn't create a trust. Okay, first of all. If you just have a Lady Bird deed as to a house in terms of who the heir, it doesn't affect anything about your insurance or your mortgage payments or anything. Okay, it just says what happens to the house when you die. Okay, now if you put the house into a trust, that's a different circumstance, okay? Because now the trust technically owns the property. So yes, insurance should be in the name of the trust at that point. But if it's just a Lady Bird deed, you don't worry about it. Oh, she typed something up.
Or Ms. Yeah, so Ms. Stewart's question online is, if you inherit antique furniture, artwork, and jewelry, do you need to get the items appraised? Who pays the estate taxes? The estate or the person getting the stuff?
Well, I mean, I guess a lot depends on the value, quite frankly. I mean, because estate taxes don't kick in until you're in the millions of dollars range. So for most of us, I wouldn't worry too much about it. The reason, though, to get it appraised is really for insurance purposes. In case there's a fire or something, you do want to make sure it's covered. And, and so you need some proof of how much it really was worth.
Monthly fees to maintain a trust.
There are no monthly fees to maintain a trust if it is just an individual who's the trustee. In other words, somebody you trust, a friend, a relative, whoever, not monthly fees. Now, if you don't have anyone specified or everyone dies off or something bizarre happens and the court has to appoint someone to be the trustee, yeah, at that point there are fees.
Rochelle asks, does a person have to be on the bank account of someone to be their POD?
No, they do not have to be on the bank account to be their POD. Okay. My sister, for example, is not on my bank account, but she is my POD. In other words, over my dead body, she gets the money.
So how do you set up the POD?
Oh, it's very simple. You simply go to to set up a POD, you simply go to the bank. You get an appointment there. They give you some papers, you fill out, address, telephone number, that type of business. And guess what? You've set up the POD.
Okay, thank you.
Pamela Rainey, mute yourself.
Hi, my question is, if my mother did not have a will, she passed away and did not have a will, and it's 5 children, and she raised one child. She raised one child, another child, but did not adopt that child. Do you have to add that child on anything? We were trying to get the house straightened out. We don't know which way to go. What do we need to do?
Yeah, well, first of all, you're going to have to file just a regular probate action. And that is one of the questions that come up that the probate court will have, which is what children are there and are there any people who they raised and treated like a child? So that person can factor in, okay? But that will be decided in terms of whether they qualify to be counted as an extra child, will have to be decided by a judge.
And the child is deceased. He's already deceased.
Oh, if he's deceased and he didn't leave any kids himself?
He have a We think he have a daughter. We're not sure.
Well, whenever a child or possible child deceases, then their kids step into the place of the person who's deceased. Okay. And I'm glad you kind of brought that up because I've had, there's some people who think, well, you know, our parents had 5 kids. The other 4 are all now deceased, so I get the house. It doesn't work that way. Okay. It's not a tontine situation. It's all those deceased kids, if they had kids, they become heirs. Now, if they die without kids, well, yes, then their group just gets split among the survivors. But otherwise, the heir of the deceased person who would have inherited steps into that new person's place.
Okay. My second question is, my mother married. I'm not sure if she divorced or not, her second husband, but he passed away as well already. But she owned her home before they were married. How do we treat that? How do you treat that?
Okay, under the laws of Texas, any property that you own before marriage or are given or inherit during marriage is your separate property. So the second spouse, his heirs have no claim on anything on that.
Thank you.
But I just want to add one follow-up point on that last one, though. The one thing you do have to think of, let's suppose that, again, back to that previous person's question that the wife owned a house before marriage. Let's flip it around. Let's say she dies first. Even though the second husband wouldn't inherit the property, he does have a homestead right to continue living there. Okay. So I just wanted to mention that.
Okay.
I have a question. Can you hear me?
Yes.
You stated that you did not need a lawyer for a transfer of death or a ladybird deed. So what papers? I'm more interested in the ladybird deed, and I don't need a lawyer.
You know, I never want 100% to say, I mean, I'm an attorney playing it careful. So I never want to tell somebody you never should have an attorney look at something. But I mean, I know plenty of people who have done it successfully, you know, as long as you fill out the form correctly. I mean, that is still the thing. I mean, it can be done. So I will say that.
Okay, my second question is, if you don't qualify for your program, but you're still a senior citizen and your income is not that great, do you all have a list of lawyers that will work with those people?
I wish we could, but the problem is we rely on funding from federal and state sources, and they have in there that we cannot refer people to private attorneys, specific private attorneys. You can imagine how it could get abused very easily. So unfortunately, we're not allowed to do that.
Dallas Bar Association does have a lawyer referral service. They do charge a $20 fee, but that is one way that you can get referred to an attorney. And their phone number is 214-220-7400.
And I guess just one practical thing in terms of looking for attorneys, since I said I can't refer anyone specific, but I can give you an idea on how to look. Okay. You know, one thing to always consider, of course, is how long have they been practicing? You want someone who's been practicing for at least 5 years so that they know what they're doing. If you find someone's ad and they say, well, we do probate, we do estate planning, we do criminal work, we do family law. Okay. If they're a jack of all trades type, well, they may not be an expert on anything. So you might want to steer clear of that. You want to have someone who somewhat specializes in it. You want to consider what part of town they're in. Okay. If they have some offices with marble floors, guess who's paying for the marble? you are. Okay, just in terms of affordability. Look at what part of town they're in. What's their overhead, you know? If they're in Highland Park, they got to pay their rent. If they're in the Oak Cliff Tower, it's far cheaper. So, and they can be just as good. Okay.
I have a question. My husband and I have a house and we have one child, living child now. Is it better if we put the house in a trust? Where does that leave us? Does that mean we still own the house? But I'm trying to understand the trust.
Okay, when you put a house into a trust, the trust owns the house. Okay, let me be clear on that. Now, what you have control over is all the terms that you want, how the trust should operate. For example, you obviously put in there that you have the right to live in the house, for the rest of your life rent free. Okay, you definitely want to put that in. Okay, and one interesting thing is if you put in that language about living there rent free into a trust, you can still claim all the exemptions. That's the language they look for. I asked them about it. Okay, so you just have to make sure you put down the details of what you want to have happen. I want to be able, for me and my spouse to live there for the rest of our lives. At that point, then the house goes to whatever. And also, you generally want to put in there, when does the trust end? Okay. Do you want the child to be able to sell the house while they're alive? Do you want them to, you wanted to keep it for a while? You just have to spell out what the terms are exactly. So it's a lot going through all the what if scenarios. Okay. It just has to be spelled out.
Okay. And how much does it cost for the trust? Is that something that, I know you said don't do the internet, so I need to go to a real person.
Yeah, you do. I'm kind of guesstimating on this because I haven't been in the private field for a while. But my guess is probably 1,500 or so. That's just a guess. Okay.
Okay. Now, one other question, when it goes into a trust, as far as the taxes and all those things, we're still responsible as long as we're alive. It just goes to him once we're deceased, correct?
Correct. That is correct.
Okay, thank you.
Do we name ourselves a trustee of a trust?
Well, okay. Yeah, this is an interesting legal thing. One point of law, okay? Let's suppose you have a trust, okay? And you're the trustee and you're the beneficiary. Legally, the trust does not exist, okay? If you only have one person involved, it voids the trust, okay? So there has to be, you need a separate trustee, okay? Now, mind you, if you're not the beneficiary of the trust, in other words, you're setting it up for somebody else, well, obviously you can be the trustee at that point. But you can't have one person wear all the hats because then under the law, the trust is invalid. You really haven't given away the property.
Hello, I have a question. Can you hear me?
Yes.
Yes, ma'am.
Okay, this is Greta Burton. I've had my hand raised. Anyway, I have a question. If there are two trustees in a trust and one trustee does not follow the trust agreement and removes funds from an account that is not per the trust instructions, what legal ramifications are available for the trust?
Oh, that can get really ugly. Basically, you're looking at a court case at that point, and if a trustee violates the trust terms, which is what you're describing,
Correct.
they can be sued for a whole bunch of money. Okay, because a trustee is what we call a fiduciary relationship. They're under a very high standard. They have to follow the trust. If they don't, they are liable to all types of damages, including punitive damages for violating the trust.
Thank you so much.
Mr. Treasurer, wanna, go ahead and unmute yourself?
I had a question. I'm sorry. This is Patricia Swindle. You gave a telephone number for a possible attorney. Can I get that number again?
Yeah, so it's in the chat, and it's also, it's for the Dallas Board Referral Service. That's 214-220-7400.
Oh, okay. Thank you. Thank you.
And my question is, how often should you update your will?
That's anytime there is a major change in your family circumstances, okay? You should bring it up and look at it. And quite frankly, even if there hasn't been a major change, look at it at least every 10 years just to see if you've changed your mind, okay? And it's just as simple as that. So, I mean, I would look at it at a minimum of every 10 years. But again, if something major happens, someone passes away, is usually the big thing. Somebody gets married to somebody you don't trust. And let's be honest, that happens too. You may want to look at things, okay?
All right, thank you.
Oh, and by the way, that does bring up one interesting point. Let's suppose you have a will and you look at that will years later and it's pretty good, but you want to change one little thing. You don't technically have to do a brand whole new will. You can do what's called a codicil, which is like a small little amendment to a will. And they're much cheaper to do and very quick. So a codicil is a useful thing if it's just a minor change.
Can you put that word in the chat so I can see it?
Okay, it's spelled CODICIL.
CIL. Okay, thank you. Codicil to my will.
And do you have Martin in the chat somewhere?
Yes, so I see a question here from Ms. Rosa. How about if you have a beneficiary on your bank account? Is that enough, or do you still need a POD?
Well, it's really the same thing. If they call it something different, it's essentially the same thing. So, I mean, they usually call them payable on death provisions, but if some bank calls it beneficiary, that's fine. It's the same thing.
Okay, that would be my question. If I already had somebody listed as a beneficiary, I don't need to go to the bank and put them as POD?
No, it's the same thing. If a bank uses the term beneficiary instead of payable on death, that's fine. It says who gets the money if you pass away.
Right. Okay, good deal.
Okay.
See 3 more questions online. Ms. Rachel asks, if both parents pass away and a house is left, what happens to it if there is no will, and a niece decided to move in and take over? Is that legal?
Okay, so, well, okay, so one niece moved in. Well, quite likely, it depends under that circumstance, because the question is whether the niece is one of the legal heirs, okay? Because the niece is the niece because one of her parents was the brother or sister of one of the couple who died. Now, if that person, the brother or sister of the deceased spouse, if they're deceased, then yes, the niece becomes an heir, and so technically she can move in. If, however, that brother or sister is still alive, no, it's not legal for the niece to move in because she's not an heir. Her parent is, okay? And that's one interesting thing that comes up when you don't have a will or a payable or a transfer on death deed or a ladybird deed, is anyone who's an heir can move into the house, okay? Which means you could have 10 people with the right to live in the house and they can't kick each other out either. And they can also, an heir can also allow, of course, someone to stay there with them. So it ends up in this horrible situation where, you may have 6 heirs, 3 want to live in the house, 1 wants to also have his, girlfriend live there with them and her 2 kids. That's why you got to decide who's going to get the house. Okay.
These with jointly one passes away. Specifically, does ownership of the entire property automatically transfer to the surviving owner?
It can be set up that way. Okay. You can, when they acquired the property, let's suppose a mother and daughter came into me and they were buying a property from somebody and they wanted, if one of them lived, that the other one would get it. I would simply put on the deed where they bought it, that they bought it with right of survivorship is the legal phrase. Okay. And that just means whoever, last person standing becomes the owner. Okay. Now, if they already own the house, let's suppose the deed just gives it to mother and daughter jointly. There's a couple different ways to do it. Probably the simplest way is for the 2 of them to do a new deed, giving it back to themselves, but with right of survivorship.
Make sure there is no abuse by trustees.
That's why you got to pick a great trustee. Okay. Nobody, trusts do not get monitored by the courts unless something's brought to their attention. You got to have somebody you really trust. That's kind of a big thing. If you want, there are rights for the beneficiaries to get what they call accountings upon request. Okay. So they can request things and see, okay, what's been coming in, what's coming out. The beneficiaries do have the right to request that, but no one's going to be doing it automatically.
You have to pay capital gains tax on a house you inherited and you wish to sell it after the probate is completed.
Okay. Okay. Yeah. If you inherited it, then at that point, if you inherit a property or either through probate or through one of the transfer on death deed or the ladybird deed, at the time of death, there is what they call a step up in basis. Okay. In other words, the taxable value, you don't have to pay capital gains from, you only have to pay capital gains from the time that, between the time that you inherited it and the time that you sell it. Okay.
So we got two more questions.
Okay, I'm fine. I'm good.
Do property taxes 65 passes, and are there any loopholes around that? Not sure if there's a question you can answer.
Okay. So the question is really DCAD raising the property tax values. Okay. It's a slightly different topic, but actually a worthwhile one. Let me kind of tell you a little bit how DCAD works. Okay. They periodically, particularly when there's a transfer in ownership and whatever, they will try to raise the taxable amount. Okay. Because they think, well, maybe no one will catch this and so forth. And once they bump it up, they bumped it up. So that's why it's important if you inherit some property and you get the tax bill for the next year, take a look and see what the old tax bill was and see if they've raised it a bunch. If they've raised a bunch, then you have to object to it and say, it really isn't a good basis for raising it up. If you look at the houses surrounding it, they're at this tax rate. Now you're trying to charge me more. And they're very good once you call them on it and say, okay, and they'll take it back down, but you have to object to it.
Can I ask?
Oh, well, that's true too.
Okay.
Commissioner Price brought in one other thing, which is, of course, if a person was getting an exemption, the prior owner, those exemptions are going to go away. I mean, that's going to come back regardless. That you can't object to.
Okay. I had a verbal question because it would be a lot to type. Um, I'm speaking on property that's not in Texas, so I know we have to go by the other states' laws, but I was part of an LLC and had property in another state, and it was four of us, and all three other people have passed away. Now, what do I have to do to get that deed or LLC in my name? It's all paid for. The
Okay,
property is free and clear.
here's the problem. Problem is, I'm not licensed in the other state.
Right.
And I am forbidden to give any type of advice on some state situation that's not Texas.
Okay. Okay. I understand that. Okay. Thank you.
Someone asked about refinancing a house with a low interest rate. And if they're over 65, can they just file a reversible mortgage?
Wait, could you say that again? I lost you.
Yeah, so someone asked earlier about refinancing a house that has a low interest rate, but if they are over 65, can they just file for a reversible mortgage?
Well, as I discussed earlier, I am extremely wary of reverse mortgages for several reasons. One is particularly for people over 65, simply because, first of all, if you're claiming the tax deferment that you have a right to when you're over 65 in Texas, you can't claim it if you have a reverse mortgage. You have to pay the taxes each year. You have to basically, I really would try to avoid it if at all possible. Okay. Particularly now, mind you, it's probably less crucial if you don't have any heirs or someone you want to leave the house to, and just want to spend the money yourself while you can, that I can understand. But if you want to leave something to the next generation, I would avoid a reverse mortgage if I could.
Any questions?
Yes. What happens if the expenses exceed the value of the estate because of the length of the probate? Attorney fees and item fees.
If the cost of the probate exceed the value of the estate, it's quite simple. The heirs get nothing. That's pretty much what ends up happening.
Follow up. I'm a dependent administrator. How difficult would it be for me to become an independent administrator because of the expenses?
If this is you're a dependent administrator and you want to find out how difficult it would become an independent administrator, well, it sounds like you're in a contentious situation, because normally you really can only do it if everybody else agrees. And I don't see, if you're in a contentious situation, I don't see people agreeing to that.
And my last question is, if you have an heir that is mentally challenged,
okay,
how difficult would it be to get guardianship? She had one son that passed away. The other son is mentally challenged, so he can't make the decisions on the assets that he would inherit. How difficult would it be to get guardianship over someone that is mentally challenged?
Okay, what you're relating is that one of the heirs is mentally challenged, and you're curious about how difficult it would be to get guardianship. It is difficult because that's a separate court case. It could be referred to the same court, but it's still a separate court case. And whoever is closest in, biological relation to that proposed or to that heir would have to apply for it. And then they have to go through the whole thing about whether a guardianship is appropriate, have doctor's reports and all this other business. Okay. So guardianships are one of the few things that's actually more difficult than probate. Yes.
father had a child on the outside of the marriage. That child apartment for the will process also.
Okay, so you're describing a situation where your mother passed away. You were one of 5 kids. Your father, though, had a 6th child outside of the marriage. And is there any particular asset you're concerned about? Was the house bought during the marriage? Okay. Well, then, yeah, you do have a little bit of a situation because that 6th child does have a claim, okay? That child's claim would be, this is the only time where fractions come in useful. You know, you learn them in school, we'll go from there. That child would have a 1/12 interest in the property, okay? You and your siblings would have, it's like a 1/10 or 1/11 or something interest. But yeah, that extra child would have a claim on the property.
Even though, let's thank George. He really, thank you very much. You don't know how many of these he's done. Those of you online, I think this is about at least for District 3. He's done at least 3 or 4 of them for us. And then I think Mr. Romaine and our SPE office is going to put all the data together. Let me just tell you, this is one of the reasons we began, like I said, not only because of the inquiries, but when we look at the property that is basically in the southern sector, how much of it was lost because we don't take care of end of life planning. You would be surprised. And there's a map, a heat map out there that shows that. So thank you so much, George. Can't say enough about it. Jason Romaine and our small business enterprise. He continues to coordinate this. Again, my staff, thank you. Home Loan Counseling Center, thank you for being here. For those of you, this is your taxpayer money at work. We appreciate it. But this is basically legal aid of Northwest Texas. And George is a member of that staff and has been just so invaluable over the last year. So I can't thank you enough. So with that being said, ladies and gentlemen, I think that pretty much staff is bringing you. Oh, for those of you, she's taking care of you on the parking end. And so if you'll see her, if you drove, we'll compensate your parking. Thank you very much for being attentive, and we'll see you hopefully in the future with your business taken care of. Thank you again.
Say something real quick.
Sure.
For anyone who has parked in Jackson or 700